That is the vaguest thing I've ever heard in my life. I mean, come on. I'm not going to read it. It doesn't matter.
It's in on video, guys. Like, I watched it. I'm not crazy. Like,
well, maybe they haven't had my case yet.
Okay.
And while
he doesn't
being arrested,
he does not go plank. It's on video, Judge.
What they say, he uses his, I guess he uses
He's in
his
handcuffs. If anyone's aggressive, it's the cop from the beginning.
This public defender goes head-to-head with the judge and two prosecutors, and what you're about to see is super rare, a courtroom 3v1 where he actually holds his own here. You would think this attorney was billing $200 an hour with how hard he's fighting for his client, as the prosecutors keep laughing at him like it's a joke, but that stops real quick when he flips the hearing with one of the sharpest defenses I've ever seen. Legally, he only has to provide efficient counsel, and this goes way beyond that. So let me know what you guys think about why more defenders aren't showing up like this guy, but let's go ahead and dive in and watch him go to war.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading, and now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate it, Your Honor.
Sure.
But be that as it may.
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was located.
What?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Okay, so as you guys can see, this attorney just picked up a client with more baggage than Spirit Airlines. I mean, this dude has over 10 cases in the past 2 years, and at that point, your rap sheet needs a table of contents. And the craziest part of this whole thing is that even with all of that, the lawyer still has to treat him like he's squeaky clean because of his presumption of innocence. Yeah, that's still a thing after 10 cases too, and court rules say the defense has to give their best shot here, though even if their client practically lives at the courthouse, it's almost like being forced to enter a rotten banana in a fruit contest and still pretend it might win. So yeah guys, just keep that in mind before we watch this attorney go all in trying to polish a legal dumpster fire.
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're a 0.1 mile away from the location. So for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there. Okay. They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have.
Okay.
Right, Mr. Zenon. There's always two sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else. Was there another warrant that you said?
It's the aggravated assault with judge. I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. All right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know,
but they didn't hit. They took the one that I do not believe applies here.
Let's read the code. Okay. Let's see what the code says, because you know there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can. You're right. It could have been like a resisting, you know, but okay. You ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is.
Okay, so the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean...
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay, Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation. And then when they were detaining him, he was resisting arrest, is what it seems like.
So, this case just took a turn because now that the judge read out the interference with an officer statute, the whole vibe shifted, and not in the prosecution's favor either. The charge may sound tough at first, but it's actually one of the slipperiest ones in court, and legally, the officer has to give a clear and lawful command, not just shout something in the middle of the chaos. So if the footage we're about to watch shows the guy just standing there looking confused, this charge might fold faster than a cheap lawn chair. And yes, we're about to watch that footage for ourselves in just a moment here, so there really won't be any more guessing, but judges do like to throw this charge around, but without solid proof, it's basically just courtroom filler. So let's buckle up because what comes next might just make this whole case unravel right on camera.
And with being
I mean, did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant. And then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushed him. That's a resist. That's not interference with public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
okay. Well, I mean, but
we don't know. I mean,
okay. I'm just saying.
Well, he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report yet.
I don't care. I mean, but I think that there's enough. He places him in custody, right? He's going to arrest him. Starts putting him in the car, and dude goes plank.
I know, but I don't have the video.
I've shared the videos with
remember,
you're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt. Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say.
3 times to search me.
Can I have a moment to look at the video? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, so
the bond right now is set at $2,500.
Okay.
Your bond upstairs is set at $5,000. I'll do whatever you want to do. You want to set tomorrow, Monday?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body cam.
I just shared
Okay,
it.
so
They shared it. They just shared it. With me.
Yep.
let's roll with it tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow.
Okay, before we jump into the hearing from the very next day after both sides watch the footage and prep their arguments, let's just take a second to appreciate what this public defender is doing. I mean, this man is putting on a full legal clinic like he's billing $200 an hour right now, not working for a county paycheck and a cold cup of coffee. And public defenders do get a bad rep, but really, they're the ones carrying entire court dockets on their backs, often with over 100 open cases at a time. And despite all of that, this guy's showing up swinging like it's a headline trial, and legally speaking, he is obligated to a competent defense. But this goes way harder beyond competent. Yeah, I just had to say that. But yeah, since everybody's locked and loaded, let's go ahead and dive in and watch how this next hearing turns everything upside down.
I'm gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So
You know that Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been meeting with his.
stating in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that, and another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that. So I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're going to file you. And then parole goes, oh, now we're going to revoke your parole. Those are the shenanigans that I've seen.
Judge,
and this has been going on for years out there, like prior administration continued.
But I mean, I guess ultimately at the end of the day, even if that happens, like let's just say the parole board's going to look and see that it was like extremely old, right? I would have a thing. Time he failed.
I'm not going to read it. It doesn't matter.
As in,
I mean, it doesn't matter. It's on video.
So I'll make a note.
Okay.
Parents required, but no,
correct.
if he pays.
On video, guys. Like I watched it. I'm not crazy. Like this, it's on video.
Sorry to keep
Let's
waiting.
talk to Judge about it.
You're still upset?
Yes. I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it, and it would have,
Well, maybe they haven't had my case yet.
Okay.
And
I don't know why, but I'm actually getting a little irritated with the prosecution here. They're laughing and mocking this defense attorney just because he's fired up for his client. And I mean, this dude is looking at real prison time and the attorney's doing exactly what he should, challenging the process to try and keep his client from serving more time than necessary. And if this probable cause conference gets tossed, it could seriously change the outcome of that dude's sentencing, and legally. That's his right. He's not grandstanding. He's doing the only thing he's supposed to do, so you would think the prosecutors would respect that or at least act like professionals or something. But let me know what you guys think. I might be overreacting here, but their attitude here is really something.
I'm happy for you to make new law, always. So why are you saying that there's no PC in this case?
Is there PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
he doesn't
being arrested doesn't
he does
happen?
Not go plank. It's on video, Judge.
Would they say he uses I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, we'll search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there go, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
Yeah, I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I asked at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge, there's-
Watch or no?
We can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow so we can all watch? Yeah, right there. You said it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him.
Now you're under arrest.
I'm under arrest.
Yep, you
What?
got a new charge, Bubba. Resistant transport.
Resisting? I wasn't resisting.
You just resisted transport. Yep. You going to jail.
What the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you,
These
Judge.
officers are working intake, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no. All right, I'm with
Do
you.
you see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not going to hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
Let me know in the comments how you think this attorney handled things, because honestly I am super impressed with him, and that's usually not something I would say about courtrooms that typically run like DMV lines with a gavel. I mean, this video really should be a gold standard for public defenders. This dude was actually fighting tooth and nail, not just standing there like a warm body waiting for their client to get sentenced so they can go reheat leftovers in the break room. And I've seen way too many defense attorneys treat hearings like they're background characters in a courtroom drama. And yeah, it actually does make perfect sense why those prosecutors don't like this guy very much, because he actually forces them to work. Funny how doing your job well becomes a problem when the other side is used to sleepwalking through cases. And it really is moments like these that remind you how much the system depends on who's willing to actually show up and care. But yeah guys, I really want to hear from you. Let me know what you think about this hearing, and also don't forget to like and subscribe. I would really appreciate it. Thank you so much guys, and take